All right, let's get right into it. Today, we are breaking down one of the most fundamental processes in criminal law. We're going to look at what happens from the very moment a crime gets reported, all the way to the beginning of an investigation, all under the new laws of the Bharatiya Nagarik Suraksha Sanhita, or BNSS of 2023.
So, when a crime happens, what's the first thing the police do? It seems like a simple question, but the answer isn't always the same. In fact, the entire direction of a criminal case is decided by the answer to one single critical question. Is the crime cognizable or is it non-cognizable?
You see, when information about a crime first hits the police station, they don't just spring into action. Their very first job is to classify it. It's kind of like a fork in the road, because the law lays out two completely different starting paths for the entire criminal justice system.
And this first step, it is absolutely the most crucial one. This initial decision, this classification, is what determines whether the police can act immediately and make an arrest, or if they have to wait for a court's permission. Literally, everything that follows hangs on this one decision.
So what is this critical difference all about? Let's break down these two key legal terms just as they're defined in the new BNSS. Because if you can grasp this, you're grasping the very foundation of how criminal procedure works in India.
Let's start with the big one, cognizable offenses. As you can see here, Section 2.1 Cha of the BNSS defines these as offenses where a police officer can arrest someone without a warrant. Now, these are generally the more serious crimes. We're talking about murder, theft, kidnapping. The law gives police this power because for these crimes, immediate action is essential to stop a suspect from giving away or destroying crucial evidence.
And on the flip side, we have non-cognizable offenses, defined right here in Section 2.1.1 Earn. These are usually less serious things, like a simple assault or maybe defamation. In these cases, a police officer's hands are tied. They can't just go out and make an arrest. They actually need to get a magistrate's permission before they can even start an investigation.
And this chart just lays it all out perfectly, doesn't it? It all boils down to two things: police power and judicial oversight. For cognizable or serious offenses, the path is direct police action. For non-cognizable ones, the path has to go through the court first. It's a system of checks and balances, really, all based on how serious the crime is.
So, what if a single incident involves a mix of offenses, some serious, some not so much? Well, the law is super clear on this, and it's been established in cases like Praveen Kumar. If even just one of the offenses is cognizable, the whole case gets treated as cognizable. This gives the police the green light to investigate everything without having to go to the court for permission.
Okay, so let's follow that first path, the cognizable path, and see where it leads. When police get information about a serious crime, it triggers what is probably the most famous document in all of criminal law, the First Information Report, or as we all know it, the FIR. Seriously, think of the FIR as the ignition key for the entire investigative engine. Under Section 173 of the BNSS, this is the formal document that officially gets the police investigation rolling. And here's the most important part. If the information points to a cognizable offense, the police are legally bound to register an FIR. It's not a choice, it's their duty. And Section 173 doesn't just say file a report. It lays out a very clear 5-step process to make sure everything is transparent and accurate from the get-go. The information can be given orally, but the police have to write it down. Then they have to read it back to the person who gave it, get their signature, and, this is crucial, give that person a copy completely free of charge.
But here's a tricky question. What actually counts as the first information? Well, case law has really cleared this up. It's not about which paper the police decide to write on first. It's about which piece of information, chronologically, was the first one to reveal a serious crime. The Moni Mohan case is a perfect example. There were some vague reports about a missing person, but those weren't the FIR. The real FIR was the later statement that actually suggested murder, because that's what kicked off the criminal investigation.
Now, the BNSS has brought in a really significant victim-friendly change called the Zero FIR. This is a huge deal. Under Section 173, you can now report a serious crime at any police station, even if it's not the one that has jurisdiction over the area where the crime happened. They have to register it right there and then they'll transfer it to the correct station. This removes a major roadblock for victims who need help immediately.
So, the FIR is filed and the investigation officially begins. But we've been focused on that cognizable path. What about the other fork in the road, the non-cognizable cases? How does their journey even start? As you're about to see, it's a whole different ballgame.
This timeline just shows the two different worlds perfectly. For a cognizable offense, it's a straight line. FIR. Under Section 173, investigation starts under 175. Boom. But for non-cognizable offenses, look at that middle step. The police log the info under Section 174, but then they have to send the person to a magistrate and wait. They can't do a thing until they get a direct order from the court.
Okay, so let's jump back on that cognizable track. Once the FIR is filed and the investigation is a go, police follow these key steps. They'll go to the scene, figure out what actually happened, identify and, if necessary, arrest suspects, and gather all the evidence they can find. This entire process builds up to a final police report, filed under Section 193, which they then submit to the magistrate.
So we've figured out that the FIR is the starting pistol for the whole investigation. But what happens when the case finally gets to court? Just how important is that very first document as a piece of evidence?
This is a super important point. The Supreme Court has made it crystal clear. An FIR is not substantive evidence. What does that mean? It means a person cannot be convicted based on the FIR alone. Its main job in court is to either back up or contradict what the person who filed it says on the witness stand. It's basically a tool to check their credibility.
But like with many things in law, there are rare but incredibly important exceptions. These are times when the FIR can transform into a powerful piece of evidence itself. The most significant is what's called a dying declaration. If the person who filed the FIR later dies, and that report was all about the cause of their death, it can be admitted as direct evidence under Section 26(1) of the Bartia Saxia Omnium.
And one last thing. Timing is everything. A court is always going to look at when the FIR was filed. If it was filed right away, it's seen as more reliable, the memory's fresh. But if there's a long, unexplained delay, that raises some serious red flags. It makes the court wonder if the story got exaggerated, or worse, completely made up in that extra time.
So, it's pretty clear that the FIR is what opens the door to the criminal justice system. It gives a voice to the victim, and it sets the entire machinery of the law in motion. But as we've seen, filing it is just the first step on what can be a very long and complicated journey towards justice. Thanks for watching.